Time's nearly 2:05, still haven't heard from you. Can you just give us a ring, please, let us know you're alright? Because at the moment I think you're dead. You just said on the telly that there's 3 men in Range Rover. I think it's you. Bye.
It is pointed out that Steele's call to the BT payphone of Bedloes Avenue, Raywith, at 11:53 on the 11th of November 1995 was in the correct position within an unused trial telephone schedule, but incorrectly appears as the last call of the day in the trial schedule. It is submitted that this difference between the schedules shows that Essex Police manipulated the data in an attempt to mislead the jury. The Commission observes that this point was raised by Steele in his trial evidence, but it was accepted by the Crown that the call appeared in the wrong place in the trial schedule. The Commission also observes that in his application for leave to appeal in 1998, Steele made the submission that this inaccurately revealed police misconduct and was aimed at deceiving the trial jury. The submission was considered by the Court of Appeal in January 1999, and so this is not new for the Commission's purposes. The same is true of Steele's submission regarding the reversed order of 2 calls timed at 20:39 on the 6th of December 95, one from Steele's landline to Steele's mobile, and the other from his landline to Wome's mobile. Steele's submission that the reversal of these calls in the trial schedule was a deliberate attempt by the Crown to undermine his alibi was before the Court of Appeal in January 1999. The Commission does not consider there is any new evidence in relation to the switching of data which should give rise to a real possibility that the Court of Appeal would overturn the convictions. The applicants submit that Essex Police, or the CPS, misled the jury by listing in the trial telephone schedules that the Saunders Tate landline was solely used by Pat Tate, and that the Street Steele landline was solely used by Michael Steele. It is submitted that Miss Saunders and Miss Street were good friends who used to talk on the phone frequently, but the jury was left with the false impression that all the calls between the two numbers were between Mr. Tate and Mr. Steele. The Commission observes that this point was raised by Steele in his trial evidence, and so the jury were well aware of it. The Commission also notes that the point featured in Ground 8 of the Grounds of Appeal drafted by Steele in June 1998 and considered by the Court of Appeal in January 1999. It is therefore not new for the Commission's purposes and cannot form the basis of a referral to the Court of Appeal in the absence of exceptional circumstances. The applicants further submit that Essex Police and or the CPS wrongly attributed mobile telephones to Craig Rolfe. It is pointed out that these 2 telephones were actually registered to Rolfe's brother Michael and to Penelope Hughes, Michael Rolfe's partner. In relation to 0973 344 913, the applicants will be aware that although this was registered to Michael Rolfe, there was evidence that Craig Rolfe was a user of the phone for a considerable period of time. According to Penelope Hughes' witness statement dated the 9th of April 1997, Michael Rolfe had obtained the phone for Craig due to the latter's poor credit rating. Craig Rolfe had used it for 13 months, but then had lost it a matter of days before he was murdered. Craig Rolfe's partner, Donna Jaggers, also confirmed that he had lost his telephone a few days before he was murdered. Throughout its review of this case, the Commission has discovered no evidence to suggest that Craig Rolfe was still in possession of mobile phone 0973 344 913 on the 6th of December 95. Nor has the Commission discovered any evidence of calls to or from this number after 1700 hours on the 6th of December 95. In relation to 0378 307 404, the Commission observes that Penelope Hughes, in her April 1997 witness statement, stated that she was the sole user of this telephone. The applicants submit that this phone was wrongly described as Rolfe's mobile in the trial telephone schedules, as evidenced by the call made at 12:04 on the 7th of December 1995, after the bodies of the victims had been discovered. Whilst the Commission acknowledges that this call was incorrectly attributed to Rolfe, and the same may be true of other calls in the trial schedule, it does not consider that this point in itself gives rise to a real possibility that the Court of Appeal would overturn the convictions in this case. In support of his allegations regarding manipulation of the trial telephone schedules, Steele has provided the Commission with an expert report by Ross Patel. The report concludes that anomalies in the telephone schedule cannot be explained as computer errors, but can only be attributed to manual revision on the part of the computer operator. The Commission has considered Mr. Patel's report and makes the following observations. Mr. Patel does not discuss any anomalies in the trial telephone schedule which have not already been addressed in Steele's own representations. Patel does not provide any expert analysis in relation to calls which were omitted from the trial telephone schedules. He merely repeats Steele's own submission that there are calls in the unused schedules which do not appear in the trial schedule. Patel's expert comment solely applies to the sequencing of calls. None of the points raised by Mr. Patel is capable of assisting the Commission or the Court of Appeal on the subject of the time of death. Mr. Patel's points appear to relate solely to the applicant's allegation that the Essex police manipulated trial evidence. Having considered Mr. Patel's report, the Commission takes the view that it does not significantly add to Steele's submissions regarding omissions, ordering, attribution of telephone calls as considered by the Court of Appeal in January 1999. As the Court of Appeal acknowledged at that stage, it was not surprising that human error had occurred in the compilation of the schedules. The Commission notes, in this connection, the complexity of the telephone evidence and the fact that this was one of the first prosecutions to feature such a large volume of telephone data. The Commission does not consider that Mr. Patel's report provides any additional support for the allegation that Essex police manipulated the trial telephone schedule in an effort to mislead the trial jury. In the absence of any evidence of bad faith on the part of Essex police or the Crown in relation to the trial schedules, the Commission does not consider there is a real possibility that the Court of Appeal would find there to have been an abuse of process in this case. Having considered all the submissions in relation to the telephone schedules, the Commission takes the view, even if one or more of the submissions on the subject were new, the Commission does not consider that any of these submissions are capable of affecting the key issues in the case, namely, the time that the deaths occurred, and the question of whether Mr. Nichols told the truth in the essential aspects of his account. The Commission considered that this was essentially what the Court of Appeal was referring to in 1999, when it stated, "It does not however appear, in particular so far as the telephone calls on the day of the alleged murders are concerned, that there were errors which in any way put a false gloss on the case."